You were hit by a driver with no license. Shouldn't it be that driver's fault automatically? Hi, I'm Frank Nunes. I'm a California personal injury trial attorney practicing law in the state of California. Join me as we answer that question. The absence of a license per se, in other words, in and of itself, cannot be used to prove that somebody was necessarily careless or negligent, as the lawyers refer to it. It merely means that the person was operating without the permission by the state to operate a motor vehicle. The person's conduct could be non-careless. It could have been done in a reasonable standard. So the absence of a license, the fact the other driver did not have a license, really does not have a whole lot of bearing in the underlying case. Now, in situations where the other driver, who was unlicensed, had carelessness involved or failed to act as a reasonable person would act, then you can still make a civil case against them, and the person may in fact receive a citation for driving without a license or sometimes with a suspended license. So people come to me all the time and say, I was hit by the person, they obviously don't know how to drive, they didn't have a license. Again, having a license, in theory, under the law, has nothing to do whether or not somebody was careless or not careless in causing the harms and losses you suffered in your car crash. Well, that's it for today's video on why an unlicensed driver isn't always presumed negligent. By the way, if you found this information helpful, subscribe to our YouTube channel. Why? So you can continue to get fresh new content every time we post another great educational video. And if you have questions, I want you to pick up the phone and call me. I can answer your questions. I answer questions like this every day. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.